We email each and every day, hundreds of times a day sometimes. Lawyers just love to email. And it's going to be those emails that are going to bite you in a legal malpractice case.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm very excited to share part 2 of this conversation with Marshall Cole. Pivoting a little bit into being a good client. And again, I think a little bit about, there's the phrase, the cobbler's kids have no shoes. I imagine that lawyers can sometimes be challenging clients because they may have their own opinions. They may just be who they are. What makes a good client, and how can one best help you help them?
A good client is someone who trusts that they're in good hands with us. And, this is what we do. And so you should feel comfortable knowing that we've got your case under control and we're going to advocate on your behalf. And like I said a few minutes ago, you have insurance for a reason, use it, and then go about your practice. Like I mean it when I say it, we'll only bother you if we need you. And some clients like to be very involved. And I tend to see that the higher caliber of lawyers say, Marshall, don't ever call me unless you absolutely need me. The lesser are redlining my discovery responses. And I'm fine with both. It doesn't bother me. I'm happy to reject redline changes or accept them. It's just sort of, I view it as unnecessary, an unnecessary use of their energy. Some people just take it really personally, and I get that, and I'm sympathetic to that. And so it doesn't faze me one way or the other. But I think to be the best client is really just to be the happiest client, just to focus on your work and not let it bog you down and beat you up. Because when it does that, it impacts you, just in your mental state. And I hate to see that. And it also, wears on you and makes you want to get the case out of your mind and move on. Versus if you're just not thinking about it from the get-go, that's okay. Now, sometimes it's inevitable. Sometimes you've got a big case, with excess exposure that's going to be stressful for the insured, and we deal with that all the time.
Are there any other areas, like nuggets, bullet points of things that people who haven't been through this process wouldn't think about that you'd like to highlight?
Email. We email each and every day, hundreds of times a day sometimes. Lawyers just love to email. And it's going to be those emails that are going to bite you in a legal malpractice case. And I've seen it going in so many different directions. Lawyers talking rudely to their clients is a big one. Lawyers talking poorly about co-counsel is a very big one. And when I'm in trial, the majority of my exhibits are emails, maybe some documents, maybe some photos, depending on the underlying case, but it's going to be emails. And humor does not translate in email. And if you're going to email, which we do, if you don't email about something, that can create problems, right? If people think, oh, well, it wasn't memorialized in writing, then it didn't happen. And I deal with that pretty well in jury selection if I have a case where there's no writings reflecting certain things. But you just have to be aware that they're there forever. And, those are going to be exhibits in your case. And so it's important to be clear with what you're saying. Same with text. I don't really text my clients unless they're very close to me, because we shorthand text all the time. And, there's nothing worse than seeing a settlement with a client get really memorialized via text because it's just not coming through. You talk in slang, shorthand, whatever it is, using an emoji. It's just not a way to communicate. And so I've had some really, really bad cases dealing with emails that had really results that negatively impacted certain firms.
Fist emoji, flag emoji, fire emoji.
I've seen them all. Unfortunately, not to repeat myself, but talking rudely to your client looks horrible to a jury. And I get it. Clients can be frustrating, but they're lay people. They don't know the law. It's your job to inform them, and you need to do it nicely. They have a right to bother you. that's you're hired to be bothered.
A mentor of mine long ago, and this was more, writing more letters than emails back in the day, but the through line to emails and texts as well is if you don't want to see it on the front page somewhere, don't put in writing. If you would be embarrassed by what was in there.
It's great advice. The other thing to add to that is if you want to send some nasty letter or email to opposing counsel, write it, go to sleep, and wake up the next day and decide whether that's a good use of your time, B, whether it's actually going to move the ball or advance anything on your client's behalf. And 9 times out of 10, or even more than that, you're going to delete it.
You mentioned something interesting, and that is you have a method or a questioning tool for cases where something has not been memorialized when you're picking a jury. Is that something that you're willing to share?
Yeah. And just to take one step back before I go there, every mediator in every mediation I've ever had tells me jurors hate lawyers. You got to settle this case. Jurors hate lawyers. I have not found that to be the case. In all of the jury trials I've done, when I do jury selection, most people have never dealt with a lawyer one way or the other. So they don't actually have an opinion of them. Some the few who have, generally it's neutral. So I'm sure over the course of some of those voir dires, I've had someone raise their hand and say, I hate lawyers, probably most likely just to get off the jury. I believe you go into it on 50-50, you're just as even as the plaintiff. If I'm dealing with a case where something's not in writing and it's a big part of the case, I just hit it head on in jury selection. I start talking about, the fact that you're not going to see these things. And, I talk about CSI, right? When that first came out, and it was really impacting how juries looked at criminal evidence, right? If there wasn't this exact scientific method or data or, fingerprint, then obviously it doesn't exist. And I sort of use that as a humorous way to walk into the subject of, okay, well, how many of you have had conversations with people that don't get memorialized in writing? Every one of those jurors, and we as people talk to people on a regular basis and don't memorialize it in writing. And so I get them to recognize and back to reality and just common sense of, we as human beings communicate with each other in many different ways, and talking is one of them. And with the advent of email, we didn't dispense with oral communications. And so I get an ongoing and like a nice flowing discussion about that. And you'll start to see the people who are skeptical or who think I'm trying to kind of condition them on that. And then I know I can see it, the nonverbal cues become very obvious because they kind of will shake their head and be like, oh, obviously there's something there and he's trying to cover it up. And that's I'm more looking for that than getting the good answers from people who don't care. So that's how I start dealing with it there. And then hopefully you pick a panel of jurors who recognize that they're going to hear evidence about a conversation that took place and obviously hear conflicting evidence about a conversation that didn't take place. Then it all depends on how much backup evidence there is going through there. But I've definitely had that, and it comes down to cases where there's settlement agreements, and oftentimes settlements on the eve of trial or during trial where things are moving very, very quickly. And so it's easier to give context to the jurors about how and why there wasn't an email memorializing that particular thing, or we're not going to call this witness. Still a lot of these decisions get made in real time, and there's just generally not an email confirming those types of things.
Well, we're talking about trial. I imagine with the cases you've had, there may have been a trial moment or trial moments that stand out to you in terms of cases you've handled. Anything that you feel was a particular learning lesson or piece of wisdom, either of great success or like, oh, this is a learning and next time I might do it differently?
I'll bring in arbitrations as well, because I
Sure.
do a lot of those.
Sure.
But I had a huge case that hinged on emails, and it hinged on one firm talking poorly about another firm. And that was where I really learned, and I, in my firm, was the firm I was representing was the one being poorly talked about. And there was very powerful evidence, very powerful, that we were able to use. And the other firm just really couldn't do anything with it. They were stuck in a really bad position. And so that was where I really got to see the impact of sort of these bad emails, and also where I really started talking when I do CLEs to lawyers about, just because it's not your opposing counsel doesn't mean you can talk shit about your co-counsel or someone in your own firm. It was just eye-opening for me. And so I talk a lot about that. You don't think twice about, oh, it's not my opposing counsel, it's not my client. Who cares how I talk about these other people? But emails just look bad. In all my trials, each one of them, it reaffirms my belief that jurors don't hate lawyers. And I also, deal with the case within the case when I get to trial, which is, in order to prevail against a lawyer, you've got to prove that but for the lawyer's conduct, you would have done better in the underlying case. And so I've really learned trial after trial how difficult that is for a plaintiff to prove. And this is why you really want to be with a firm with experience, because there's motions in limine we file. There's jury instructions that we request that are specific to these very nuanced issues. And so the case within the case can be difficult, and judges have a lot of discretion as to how they're going to run the case within the case. We always try to require that they literally retry it, but some judges will allow you to read deposition testimony from the underlying case, and that brings in certain issues. And so not knowing what you're doing and not knowing what might come up in dealing with the underlying case is huge, because if they don't prove that, then you're going to non-suit them on an element and perhaps be done before you even get to verdict.
I don't believe this is the place for us to all of a sudden start doing an hour-long side lecture on artificial intelligence and its use in the law. But I do want to provide a platform for ways in which you have seen it influence the personal liability sphere to the extent that it has, in terms of defending cases or analyzing cases.
As you know, and the people who we've spoken to know, I'm a big proponent of AI, as are you. And I haven't yet seen it come in the door as far as a claim, someone using AI and getting in trouble. We've all, as lawyers, presumably heard about the firms that have gotten into trouble for citing cases that don't exist in briefs. Just happened recently, a month or two ago, to another firm, and they got sanctioned. Everyone's getting sanctioned for doing it. I use AI creatively as a tool. I don't mind ChatGPT, but I'm not using it to get cases. I'm using it to discover trial themes, or if I'm deposing an expert witness in a field that I'm unfamiliar with, give me 50 questions on this particular field. If I get 2, huge success, because it took 10 seconds to get it. So I look at it and I urge everyone I speak to about it. It's if you want it to do your job for you, I think you're taking a big risk. A lot of times it probably can, and there are a lot of people I know that are trying to have their firms run by AI and be sitting on a beach somewhere. That's fine. You're taking a risk, but the technology's there, almost there, wherever it is. My firm's not taking that approach. I look at it as just another resource to add value to on my client's behalf. And that's how I'd use it.
If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts, and consider sharing an episode with a friend. Additionally, We want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@kupris.law. As we kind of coming into the final stretch, is there anything else, any other area that we haven't talked about, wisdom, pieces of cases, tools that have been beneficial to you that you'd like to share with our listeners?
On the technical side, I would say a lot of lawyers don't think about breach of fiduciary duty. And a lot of lawyers think, okay, I get sued. It's a cause of action for maybe breach of contract, legal malpractice, and that's negligence. Breach of fiduciary duty and a breach of fiduciary duty cause of action creates complexities to your case for the following reason. And a breach of fiduciary duty can come from most common is going to be a conflict of interest, an undisclosed or unwaived conflict. It could be many other ways. And the more I do CLEs and talk about what I'm about to say, I feel like the more plaintiffs' lawyers listen to it. And so they know to add a breach of fiduciary duty cause of action. So I apologize for this, but it's good to know on the defense side and as lawyers as a whole, just so you avoid it. But there's negligent breach of fiduciary duty and intentional breach of fiduciary duty. If you look at the jury instructions on intentional breach of fiduciary duty, the word intentional does not show up in the jury instruction. It's not like fraud where you have to intend to act, intend to cause harm. It's nothing like that. Rather, if you failed to get a conflict waiver and represented two clients, one would argue, well, that was negligence. I just didn't do it. On the flip side, the plaintiff's lawyer is going to argue, no, that's intentional. You didn't do it. And unfortunately, you're likely going to fall into the category of the intentional breach because the way the jury instruction is worded. And there are two big issues if you find yourself facing an intentional breach versus a negligent breach situation of fiduciary duty. One is it's not going to be covered. Intentional conduct is not covered by your professional liability policy. So your fraud, all those causes of action, you're never going to get coverage for anyways. But intentional breach, it's a gray area. It's not fraud, right? It's much different than that, but you're not going to get coverage for it. So that's number one. Number two, the causation standard is different between negligent breach of fiduciary duty and intentional breach of fiduciary duty. With negligent breach of fiduciary duty, it's the same as legal malpractice causation. But for the lawyer's conduct, what would the result have been? But for the breach of fiduciary duty, what would the result have been? You still have to prove that actual damage. On the intentional breach side, it's a substantial factor causation standard, which is, you would know, Miles, as a plaintiff's lawyer, much, much easier to prove than but for causation.
Yeah.
And the damages that you can recover for an intentional breach of fiduciary duty, you can get non-economic damages and, importantly, emotional distress damages. There's a case called Knutson versus Foster, a good case to read, which allowed for the plaintiff to recoup emotional distress as a result of what the lawyer did. Now, think about it. If you've got substantial factor causation, you don't need to have economic monetary loss. You could have just the emotional distress, right? This lawyer screwed up my case. He sold me out. It was a total conflict. It was the most stressful situation of my life, ruined my life, emotional distress. Give me $1 million. And the one thing I've found in trying these types of cases where I think lawyers and really anyone in a position of ownership over someone's well-being, which I think we have when we're lawyers for cases, we take ownership of that issue in their life, is a lack of sympathy for the lawyer if something goes wrong. It's easy for a plaintiff's lawyer to sell to a jury that this was the most important thing in this person's life, and this lawyer didn't take care of her. It's very powerful. And a jury really, I've watched jurors just eat that up because I've defended a couple of these cases. We've had to take them to trial, tried to resolve them, couldn't resolve them. And they're tough cases to defend because plaintiffs can be sympathetic. It's easy to sell that I came to this lawyer in this situation. I trusted this lawyer. I never trust anyone again. And you've got a problem. So it's a bit of a long answer, but it requires that explanation to understand the difference between a negligent breach and an intentional breach. And if you face yourself on the latter, it creates problems for your case. And obviously, we deal with it. And it doesn't mean you're going to pay out of pocket to resolve the case, but it could mean that if you go all the way to trial. And you just need to be aware of that risk.
At a top level, can a lot of that exposure be resolved with conflict waivers?
Oh, of course. If you do things right to begin with, then you're not going to face a breach of fiduciary duty cause of action. Now, I truly believe that I've spoken so many times that my friends on the other side know what to do. So they'll allege it just to throw it in there. And we can demur it out if it's truly duplicative of a legal malpractice cause of action. We'll get rid of it. I mean, it's got to have teeth at the end of the day. And 7 out of 10 don't have teeth. They just allege it. And it's not a big issue. No one needs to freak out about it. But if you do find yourself facing a legitimate one, those are issues. And it creates the causation standard is one that people really don't focus on as being a much easier pathway for the plaintiff to get a verdict.
As we talk about conflict waivers, do you have thoughts on whether a conflict waiver should be a completely separate document or whether it is okay to have that as a clause within a representation agreement that you just kind of default to have in and edit out if there's no second? And I'll explain why I'm asking the question.
Yeah.
In almost any case where the clients are married, there is an injured person and then there's a potential loss of consortium claim for the spouse. And while the loss of consortium claim oftentimes doesn't have a lot of independent value, sometimes it does, but oftentimes it's a derivative claim. It's kind of brought along to help the insurance adjuster put a little bit more money in a bucket. Oftentimes it's not one that you want to put before a jury, but at the same time, you need to make it available.
Yeah.
And there is the potential for conflict. And I know a lot of firms will do that as a conflict waiver within the rep agreement.
I would do them as separate because the client can void a retainer agreement at any time, right? It's just, they can fire you or if something's wrong with that retainer agreement, it's voidable at the client's option. You don't want the conflict waiver to be a part of that. It's similar to on the plaintiff side, if you do referral fee agreements, some lawyers put them in a retainer agreement. Not smart, because again, if that retainer agreement gets voided for some reason, there goes your referral fee agreement. Same thing, there could potentially go your conflict waiver. Now, I know there's provisions within the retainer agreement that you could put in that say just because one provision may be void, it doesn't void the whole thing. That doesn't necessarily apply to retainer agreements because it's a much different type of contract that is 100% of the time and generally going to be viewed in favor of the client over the lawyer. We see this a lot with arbitration provisions. We could talk for a whole other hour on arbitration and whether it's good or bad. But if you don't dot your I's and cross your T's in your retainer agreement, we've had retainer agreements be voided and there goes your arbitration provision. And by that, I mean, lawyer may forget to send a fully executed copy of the retainer agreement to the client, which is required under the Business and Professions Code. So if the client comes in and signs a retainer agreement in your office and they don't leave with a copy or you don't send them a copy, you didn't comply. And we have lost motions to compel arbitration, which were affirmed on appeal because of not the failure to strictly comply with the rules. And that may seem like there was no dispute. It was signed, the client, it's just, I didn't get a copy of it. Tough judge, tough ruling, correct. Technically. And, would every judge rule that way? Probably not. So what does it take to separate it out? It's not a big deal. And it's cleaner anyways. And then if something happens to your retainer agreement, that's fine. If something happens to your conflict waiver, they're both fine. So it's no need to jumble everything together.
I don't want to spend an hour on arbitration clauses.
2 minutes?
But I am interested in your thoughts because I know that some lawyers will include arbitration. And I'm talking over my own thoughts because my mind is moving too fast. In the plaintiff space, where plaintiffs' lawyers, consumer lawyers fight arbitration clauses determine arbitration clauses are terrible, you will still see arbitration clauses sometimes in those same plaintiffs' lawyers' representation agreements. Do you have opinions on pros, cons? Should lawyers be using them? Should they not be using them?
My firm uses it. It's similar to choosing insurance. You really you need to give it actual thought. If you just have it because you went to some seminar and some person speaking said arbitration's the best thing in the world without doing any research, you're not doing yourself a favor. It's very expensive. It's getting more expensive year by year. So I think the old case law and the common knowledge and thought process was it's cheaper and it's quicker way to resolve your dispute. I don't think that's true anymore. It's certainly not cheaper because people would think, well, it doesn't span 2 or 3 years, so you save the legal fees that you would spend in that time. I've had arbitration span 2 or 3 years. While some may be shorter, things get continued. And whatever, even if it is shorter, whatever money you save in legal fees paying me, you spend with the arbitrator for $10,000, $20,000 a day of their time. And I don't fault the companies that do arbitrations. It's a business and costs are high and they've got to make money. But the benefit obviously is it's private. So if you have a type of practice, and we have a lot of clients who don't want a single thing in the public eye, they don't care if it's more expensive. They don't care if it takes longer. They just want it private. And I get that. There's another important consideration or considerations, which are you don't get a right to appeal in an arbitration or only on very, very limited issues, right? So if the arbitrator makes a legal error on an issue, you can't appeal that. It's so limited. And in defending lawyers, we've got a lot of weapons at our disposal to handle your case. We get rid of a lot of cases on summary judgment. And because causation, it's so hard to create a triable issue of fact on causation in a legal malpractice case that we have a really high success rate. You're not going to get that in an arbitration. And so the arbitrators, you could bring an MSJ. I'm sure we have, and I'm sure they've been denied every time because they're going to want to have it heard on the merits. And so then you got to be prepared to try your case to an arbitrator. And we get great results, and sometimes you get mixed results. And no matter what it is, you're stuck with it and you can't appeal. So if you're not thinking about all those things and what makes the most sense for your practice, and you just have one in there, 9 times out of 10, I will have the discussion when a case comes in and I'll say, do you want to invoke it? Because most plaintiffs will file in the superior court and will have to petition to compel binding arbitration. Some insurance carriers won't allow you to invoke your arbitration provision without consulting with them, or you risk losing coverage because some very much dislike being in arbitration. And that's an important consideration to think about when you're buying insurance. So there are a lot of factors that go into it. And if I see a case where I think we've got a great chance at an MSJ, and I think I've got a judge who I know isn't shy about granting dispositive motions, I'll say, unless you really want to keep this private, let's go to the superior court.
Interesting.
And it's because of the experience with jury trials. I can say that because I know I'm comfortable taking that case to trial with a jury. There may be certainly cases where I say, let's get this thing in arbitration because we don't want it in front of a jury.
I can see why this could be an hour-long conversation on its own.
Yeah, arbitration can be, I think I've done I have PowerPoints on hour-long presentations for arbitration because, yeah. And unfortunately, most people don't think about it. And also people choosing which company is going to preside over it is very, very important. Depending on who you choose, you might have someone with 0 qualifications who's not a retired judge versus someone who works for a very reputable company who's a retired judge that we know has tons of experience handling arbitrations and with respect to legal malpractice claims. Makes a huge difference.
We followed that tangent down a good rabbit hole, but I'll bring it back to the question that teed us off in terms of you bringing forward the fiduciary duty piece. And that is, are there any other areas that you think it would be useful for our listeners to know about?
I think without doing a full CLE presentation on some of these issues, your listeners have a good understanding now of probably two or three or more things that they haven't thought about and can improve their practice in the back office and how they operate with clients, which I think should be hugely beneficial. I think about these issues routinely. I've got a retainer agreement sitting right in front of me here, and I got a separate conflict waiver. And so these issues are things that we deal with in our practice on a daily basis and are constantly changing and thinking about and modifying. And I urge all your listeners to do the same thing because things are always changing.
Hmm. Well, Marshall, I really want to thank you for your time today. I really enjoyed our conversation.
I really appreciate you having me on, and I look forward to our next AI presentation in a couple months. And it's been great having. I really appreciate it.
Well, I'm looking forward to that too. Thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions you have for who you'd like to see on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.